All right, so I'm going to get started while we're waiting for folks to join. So thanks everyone for coming to our training today. I'm Sharon Campo, supervising attorney here at Legal Services of Long Island with the Legal Support Center for Advocates. And today we have a supervising attorney, John Patanchev, and one of our paralegals, Brendel DeJoe. I'm probably not saying your name right. I'm sorry, Brendel.
It's DeJoya, and I'm one of the staff attorneys.
Oh, staff attorneys. I'm sorry. I haven't met you yet in person, so. So anyway, we have Brendel and John Patanchev with us today who are going to be doing the training on how to challenge a DSS Shelter Share requirement. But first, let's just talk a little bit more about Legal Services of Long Island and our housekeeping. So please keep your microphone muted so that way we just don't have any background noise. Please put questions in chat and then we will address them at the end of the presentation. We'll also have some polls throughout and a survey at the end for folks to answer. So if you are unfamiliar with Legal Services of Long Island, we handle over 6,000 cases every year, which includes direct representation, brief phone consultations or other brief service and referrals to other entities. We have offices in Hempstead, Islandia, and Riverhead, and our case handling staff includes attorneys, paralegals, and social workers. We do have partnerships with community agencies, whether it's Empire Justice or Brighter Tomorrows, um, but we do work with other organizations on the island. So these are our three offices, Hempstead, Islandia, and Riverhead. We do have three different phone numbers depending on where the clients reside, but any phone number will get you to a receptionist to be screened for services, and we do accept walk-ins as well. We have about 20 different units in a variety of different areas of law, or so such as family law or consumer debt, but it could also be depending on what's going on with the client. So we have disability and health related units as well. So for example, we have an education and disability rights project or an HIV unit, mental health. We have a large housing unit, including eviction prevention and foreclosure prevention, and other different areas of law, whether it be our public benefits unit, which is with us today, our NASA benefits unit with John and Brendel, Human Rights Project. It could also be a population-based unit, senior citizens or veterans. So we have a variety of different areas of law, which leads us next to our website. We have our programs on there with more descriptions of each program. So if you have any questions, you can always go to our website to check it out, see if your client or whoever you're advocating for might fit into one of our programs. We have our legal lessons that we send out every month with advocacy tips, provide trainings. Our next training is coming up in April in domestic violence. Haven't gotten out the outreach on that, but just we'll let everyone know about that. We also have self-help resources on our website too, such as fact sheets or maybe some samples for folks if they're advocating for themselves. So just a note, all of the info, information we're discussing today is legal information. It's not legal advice. Legal advice depends upon the specific facts of each situation. And the materials that we provide with you today cannot replace the advice of competent legal counsel. So definitely always, work your best to have counsel to go over whatever you are going through. So one of the things I did want to, before we get into the presentation, I just want to see what type of folks we have with us today. So I'm just going to do a quick poll here. Let's see. So if you could just answer the question, what type of advocate you are, whether it's, what you're a social worker or you're a law student or you're just here to learn. So if you just give us an idea. Thanks so much. Okay, I'll give another few seconds. Okay, so end the poll and share the results. So it looks like we have quite a few social workers, attorneys, folks who work for nonprofits, some church volunteers, and a few others. So thanks so much for joining us today with our Legal Support Center for Advocates training. And I think I'm going to pass it off to John now.
All right. Thank you, Sharon. So as Sharon mentioned, I'm the supervising attorney for the Nassau County Public Benefits Unit for Legal Services of Long Island. And this training kind of was inspired because of an influx of calls that we were getting from clients, initially starting out as clients that were being housed by DSS, that were being told by their caseworker or other DSS staff that they were going to have to start paying the full shelter share. And that was, something new. It was starting first as just like verbal warnings, and then we started getting letters and notices, official notices from DSS that this was going to happen. And this seems to have been more of a something that kind of came up with Nassau County DSS. It doesn't seem to be as strictly enforced uh, in Suffolk, according to our staff in Suffolk. But certainly the same rules will apply. What is a shelter share? So a shelter share is a client's or homeless client's rent or what they're supposed to pay to DSS while they're on temporary housing assistance or THA. And there's a directive 16 ADM 11, which basically advises when a homeless client that's being housed by DSS, what doesn't matter whether it's a hotel or a shelter placement, if they have available income, either earned or unearned, that must be budgeted into their temporary assistance um, budgeting rules, and that person would have to pay a portion of their income towards the housing. DSS is required to inform the homeless client in writing how much they're supposed to pay, when and where to make those payments. And that usually is when they get approved for the housing. Initially, they'll get a notice saying that have been approved for TA and also THA, and and it'll have all their budget of what their income is and what their standard need is for the household, and it'll also inform them what their share is. So that's where it starts, is a notice from DSS. Anything before that is not official until they actually give them a notice saying what their shelter share is, and it's usually in that first notice of when they're approved for TA or THA. Okay, next slide. So how is it calculated? So they're supposed to use the normal TA budgeting rules, except they're instead of using the shelter allowance, which for those that are not familiar, when someone is being reviewed for temporary assistance, there's a standard of need that they'll calculate for the household, and it depends on how big the household is, if it's one person or multiple people, and the numbers adjust. And so there's a shelter allowance that is factored in based on the size of the household. That number is a number that hasn't been updated, along with the other standard need figures, haven't been updated in many, many years. Um, so when a homeless client is they're trying to figure out what their shelter share is, they're not supposed to use the shelter allowance to factor in the cost of the housing, but the actual cost of the housing. Uh, so that means that as a result, someone that may be on SSI who typically wouldn't qualify for TA because their SSI benefit is usually more than the standard need if they're a household of one. If they're homeless, they're going to be eligible for TA and THA because the actual cost of housing is going to be a lot more by itself, usually a lot more than just their SSI payment. So that's why you'll see clients that typically wouldn't be approved for TA in their notice for emergency housing. They'll say they're eligible for TA. They won't really be getting anything other than the DSS providing the housing for them, but that's why it's kind of linked together. And so they're supposed to be using that the maximum the actual cost of the housing um, instead. And DSS has the right to ask for the full amount. Before I believe like the spring of last year, typically DSS would accept, at least Nassau County DSS, that's my experience, and me and Brendel's experience is they would take whatever the client would give. I mean, if they gave $200, that would usually be enough. They ask again for the full amount, but they typically didn't enforce it strictly. But since the spring of last year, we've saw a dramatic increase in DSS asking for the full shelter share, and um, that has led to a lot of fair hearing decisions that we've been able to prevail on. But it's also made this issue in our public benefits unit our number one issue last year, which it never really was. So this was a big topic, and it's probably still is, and could be for a lot of your clients going forward. So next slide, please. So here's an example of how a shelter share budget is calculated when there's no income in the household. So a mother and two children under the age of 18 are residing in a homeless shelter in Nassau County. Meals are not included and the family is not able to prepare meals in the shelter. So as I mentioned before, there's a standard need calculation for it's the basic needs, the home energy and supplemental home energy, or the HIA, the SHIA, the shelter cost, and then the restaurant allowance, $64 for the mom and $100 for each child. That total comes out to about $4,153 as their standard need based on their budget. But the family will receive a cash grant of 653 because DSS will take the difference between what the total cost of their standard need is and the shelter cost, and whatever's left of that is what the family will get as a cash grant. So in this situation, there is no shelter share because the family doesn't have they don't have income to pay towards it. So in fact, they're actually getting money. They're being housed by DSS, and they're also getting a cash grant. But in our second example, which is the next slide, when we add in, if the mom is just receiving $1,500 per month for SSD benefits, same numbers, but the 1,500 income, the DSS will pay the shelter or the hotel, whatever it is, 2653, and the difference between that amount and the shelter amount is what the client is expected to pay, which in this situation would be 847. And this represents about a little over 50% of the household's income, which is actually, for most of our clients, this would actually not be so bad. But this is because we typically see situations where the shelter share is dramatically higher, usually 70 or 80%. But even this situation, which comes right out of the ADM, 1611, 16 ADM 811, this example comes out. The idea that a lot of our clients that are homeless, they've probably had some problems paying a landlord or the mortgage, and typically 30% of their gross monthly income is considered like an affordable amount. Anything that gets above 40% is considered kind of gets harder for them to pay. That's always been the standard in when factoring like what's an affordable payment for a client when they're being housed. When you're asking them to pay 50% or more towards their income, towards emergency housing or any type of housing, it doesn't, it's not a surprise to see clients not be able to pay that because it's such a large amount. Um, so something to think about, because this is kind of impacts, a lot of our clients just come in and say, I just can't pay it. They're just asking for way too much. And there's really nothing we, can do in the sense of, well, there are things we can do, but it's an unfortunate situation because they do need the housing, and they just don't. The requirement pretty strict on what they're supposed to pay. But there are some ways around it, which we'll go into. So that's the next slide. So when can DSS discontinue THA? So one of the ways they can discontinue the THA is if the shelter share is, well, I should say that I should back up. The shelter share requirement is part of their independent living plan, which requires a lot of other things that the household is supposed to comply with DSS. So when a client unreasonably fails to comply with the ILP, DSS can discontinue the client's THA. Now, if the client unreasonably fails to comply with the ILP 2 or more times, DSS may place a 30-day sanction until the failure ceases. So it's only after the second time that they failed to do it that they could potentially be sanctioned and cut off of THA. If, and this is important, if the termination notice says that they're terminating because of a failure to comply with the ILP. The next slide goes into the other situation, which DSS can also choose, which is just not paying the shelter share, not specifically referring to the ILP in the notice, but saying that the client didn't pay the shelter share. That then will mean that there is no, doesn't have the same penalties as non-compliance with an ILP. There is no disqualification period for just failure to pay a shelter share. The client can immediately reapply and agree to pay the full share the next day after being terminated. But if the client fails to pay again, the client must demonstrate compliance in the second instance of failure. So there is a distinction. A lot of times we'll tell clients to go back to DSS, reapply, and the workers at the window or the caseworker will refuse to reopen their case. This typically requires an advocate to reach out to DSS to get them to reopen a case. But there are 2 ways that DSS can terminate a THA based on either failing to pay the shelter share or not complying with the ILP. And so you'll want to look at the notice that they get to see what their reason is for terminating, because the way it's phrased can mean either that they're at risk of being sanctioned or they just have to reapply and just claim to comply, making a promise to comply, uh, or if it's the second time that they fail to pay, um, then they'll have to actually provide the money to get back, have their case opened. Next slide. Okay, what happens when a client is notified that their THA is being discontinued? So DSS, as I said before, must issue a notice of discontinuation. Client must request, if they want to fight it, request a fair hearing within 10 days of the notice to obtain aid to continue. They have 60 days deadline to request a fair hearing, but realistically, you want to get that request in within 10 days, and the request, like any other fair hearing request, can be done by calling OTDA, by filing the form online, or submitting the form, I believe, in fax or mail. We prefer doing it online or phone, preferably online, just because you get a record of it immediately that it went through. But all of them are acceptable ways to do it. And the fair hearing will be given on an emergency basis because this is an emergency grant. This is an emergency program. So the date may be typically like 2 weeks out. We have noticed, and maybe others have noticed as well, that especially with the emergency hearings, sometimes we'll get notice of the hearing a day or 2 before the actual hearing date, because OJDA has been very slow to getting out those notices. Even the notifications of a fair hearing request are delayed. So I recommend calling OJDA once a week if you know that you have an emergency hearing coming up, but don't have a date yet, because those could be scheduled pretty quickly, and you could be caught flat-footed if you find out in the mail that it's like tomorrow. Um, so again, and the aid to continue will continue until the decision is issued by the ALJ or OTDA. see if there's anything else I want to touch on this. No, I guess that's really it. Okay, thank you. Keep going. Next slide. Yep. All right, great. So steps DSS must take before discontinuing THA. They need to determine if there is a need for APS or CPS referral, and that's required by regulation, and there's a fair hearing decision that points to that requirement. THA assessment must be conducted before they discontinue, and they can't rely on previous assessments. It has to be one that's done, you know, around the time of their attempt to discontinue, right before the discontinuance. A referral to APS or CPS has been included in the THA assessment from what we have seen in DSS case comments, but this goes to the same point that the assessment referral has to happen pursuant to failure to comply with the rules. And they can't rely on, like I said before, they can't rely on an assessment that was done at an earlier time. There's also a fair hearing decision that points to that principle. I believe, Brenda, that was the next slide. All right,
Yes.
thank you.
Thank you, John. Okay, so continuing with steps the DSS must take before discontinuing THA, they have to provide an adequate and timely notice. And this code, rule, and regulation right here is a long list of what has to be on that notice. The list is much longer than what we have here on the slide. But basically, to be adequate, it has to meet all of the requirements of this regulation here. For reductions, the previous and new amounts of assistance or benefits provided has to be on there, the effective date of the action, the specific reasons for the action, the specific laws or regulations that the action is based upon, the recipient's right to request an agency conference and a fair hearing. Those are two separate things. The procedure for requesting an agency conference or a fair hearing, and basically the contact information for the OTDA to call and request that. So that's adequate. Timely means it has to be 10 days before the discontinuance is happening. So if they're discontinuing someone on April 6th, saying that April 6th you will no longer be housed, the notice has to be issued 10 days prior to that. So usually when the client comes to you, it's at the point where they've received the notice. So your first line of attack would be go through the notice and make sure you see all of this info here. And then if it's inadequate, include the notice in your brief when you submit it to the OTDA. Personally, during the hearing, I'll question the client on what is not in the notice, just to show the judge that the notice is not accurate, or if it's not timely, also bring that up in your questioning. And then if anyone is interested, another fair hearing that goes into these details is 883-0279Y. And next slide, please. So as I mentioned before, the timely notice means it has to be at least 10 days before the proposed action. And the reason why we're going into these details that have to be on there to make it adequate is because we have seen DSS hand people and LDSS 4002. We usually see those for one shots. It's to meet an immediate need. This is not an appropriate notice. DSS is not supposed to give these to show people that they are being discontinued for their THA. Nassau County has gotten a little better with their notices since we started challenging them on this. Again, I'm not sure what's going on in the other counties, but if you have a client that comes to you with the discontinuation, always check the notice. Next slide, please. So just two more notes. If DSS is simply moving a client from one shelter or hotel to another, they're still providing the THA. They don't need to provide a timely notice. So they could tell the client, you're being moved as early as tomorrow. But an adequate notice still has to be provided in case the client needs to challenge the adequacy of the new accommodation. This could be a situation where your client has a reasonable accommodation for a physical or a mental disability, and they need to make sure that they're still being accommodated for. So the adequate notice is still required for that reason. Timely and adequate notice and an opportunity for a fair hearing is required when the transfer to another temporary housing accommodation would result in the PA grant being changed. So one example we have here is when someone is in a shelter that does not serve meals and they are eligible for the restaurant meal program, the RMP, but then they're moved to a shelter that serves food. Timely notice is required here unless the person signs a statement providing that they no longer need this. Next slide, please. So as John mentioned before, just before I go into this, not being able to afford the shelter share, that reason on its own is unfortunately not a valid defense. There has to be a reason why the client is unable to pay it. And a big one is mental or physical impairment. And with a mental or physical impairment, in order for DSS to find out if a client has that, there has to be an assessment done. So under 16 ADM 11, DSS has to assess the clients for impairments that interfere with their ability to pay shelter share. If the assessment is not done, that's your argument, is that the assessment needed to be done, it was not done, therefore DSS has improperly discontinued the THA. You can still argue that a client may not be discontinued because they have an impairment, even if an assessment was completed. And that can look like a few different things, and it all requires you to, or all these attacks would require you to comb through the case comments. Those are the notes on file that DSS has about each client. So there may be a situation where an assessment was completed, but an obvious impairment was missed. Like if somebody has a walking disability and they go into DSS every day with a wheelchair or a walker or any other kind of mobility aid. If you see an assessment in the case comments and it doesn't even mention the walking impairment, then bring that up during the fair hearing. Question your client about how the impairment affects their ability to pay shelter share. Another situation could be an assessment was completed and an impairment is not obvious. So this might be something like a dietary restriction that is causing them not to be able to pay their full shelter share, a mental disability. Look through the old case comments and see if DSS ever recorded that anywhere, even just in conversations with clients, because then you could use that to say they did this assessment, but they did not give serious consideration to the impairment that they know my client has. And then another situation could be the assessment was completed and the impairment is mentioned in the assessment, but they discontinued anyway. For that, you can argue that DSS needed to refer the client to an appropriate qualified professional to be evaluated. And we'll go into that, I believe, in the next slide or two. So just looking at the slide, THA will not be denied or discontinued for failure of the individual or family to comply with the ILP when such failure is due to the physical or mental impairment. So it can't just be that they have it, it has to be the cause for why they're not paying the share. And then claims that a mental or physical impairment was the cause of noncompliance must never be dismissed outright, but must be given serious consideration and investigated further. This is from 16 ADM 11, and this language is really important because this goes back to what I was just saying, that if they have it in the case comments anywhere that your client has an impairment and they didn't investigate further during the assessment, then attack them on that. Next slide, please. So some examples of mental impairments, these are found in 16 ADM 11 as well. We've got severe anxiety, nervousness, acting out, hallucinations, disorientation, confusion, inappropriate responses or reactions, non-responsiveness, mood, depression, agitated, disruptive, or hostile behavior, poor concentration or attention span, multiple extended hospitalizations, periodic confinement in a mental institution, history of treatment in a mental health clinic or by a private therapist, and high prescription medication usage. Mental impairments, they're a little harder to prove. Having a doctor's note helps. Actually, if you're arguing an impairment, you should have a doctor's note in your brief when you submit that to the OTDA. There is one interesting fair hearing decision, and that is 7576734H, in which the appellant was observed falling asleep in DSS many times, and the staff believed that they were self-medicating due to a mental illness. The appellant actually denied having mental health issues, but the judge still directed DSS to withdraw the notice and have them screened by an appropriate medical professional. So even if your client denies having a mental impairment, but you see evidence of this in their case comments, it's still something you can argue. Next slide, please. So examples of physical impairments: restricted mobility, inability to walk without aid, amputation, paralysis of limbs, uncoordinated body movements or palsy, memory loss, blackouts, poor vision, blindness, inability to read print, poor hearing, deafness. Walking impairment is a pretty big one. I mentioned it earlier. There's a ton of favorable case law for people with walking impairments. And during your hearings, when you want to show why this impairment is preventing you from paying the shelter share, think about like transportation issues, if that's relevant, if it's relevant for your client, if it's relevant for you, if you're self-representing. Somebody with a walker or wheelchair might not be able to take the bus due to their equipment. Are they spending money on Ubers? Are they paying people to drive them places or borrow their cars? Just question your client about how the impairment affects their daily life and where money might be going that's not going to shelter share, because that's how they need to get around to essential places like the grocery store, the doctor's offices, or things like that. Ask them how the impairment is working against them. Next slide, please. So if there's an impairment present, a referral to an appropriate qualified professional may be needed to determine if the impairments are the cause of the noncompliance. When DSS refers people, the doctor will fill out a report, if it's a doctor, or whoever the qualified professional is. They'll fill out a report and they'll give it to DSS, and you'll have to ask DSS for that report. I wouldn't trust them to put it in their evidence packet when it's time for a hearing, just because they'll usually put in their evidence packet some case comments and the budgeting that they have for each client. But if you know that this referral has happened, ask them for it and then see what the professional wrote. So one example is this fair hearing here. DSS didn't meet their burden of showing an appropriate qualified professional. They didn't refer somebody to determine if the compliance was not because of an impairment. So DSS lost that case because of not proving their burden. DSS has tried to argue that there is no mental or physical impairment present when they assess the client, and the client denies any issues. Here's a fair hearing where the ALJ ordered that, the administrative law judge ordered that DSS withdraw their discontinuation notice and refer the appellant to an appropriate qualified professional because she was observed with impairments despite denying them during the assessment. Actually, I think that's the one I just mentioned before. So it's best practice to get a doctor's note when documenting an impairment. If there's been a referral to an appropriate qualified professional, get that. And even if your client denies having an issue, look through the case comments and see if DSS has observed anything. Next slide, please. So inadequate or untimely notice, like I mentioned before, that's the first thing you're looking at. That's the first thing you should challenge. No determination of an adult protective service or child protective service referral being made. To determine that, look through the case comments and see if they have notes about whether one was considered. If there's no mention of these at all, challenge that. Unless it's irrelevant, like your client is childless, then you don't really have to think about CPS, but APS. Many times the case comments mention the referrals, but they've accurately determined that the client does not need one. That's fine. But you're just looking to see if a referral was made or if they've made a decision not to make one. So DSS DSS discontinuation pending. DSS may not discontinue public assistance on the basis of client failing to pay shelter share when the determination to discontinue THA is still pending. We've seen DSS prematurely say you no longer have a housing cost, so your public assistance grant is being changed. They're not supposed to do that. They're supposed to wait for the fair hearing decision. DSS not meeting their burden at the hearing. This can be because they didn't provide an evidence packet, or they didn't appear and they didn't send in the evidence packet as a waiver of appearance. DSS not showing documentation of an assessment, or DSS writing in their case comments that an assessment was done but not providing the report. So we've gone over that. And like John said earlier, it can't be an assessment that was done way before the discontinuation. So we've seen DSS try to say, we've assessed this client when they first showed up and applied for THA 2 years ago. That's not okay. They have to do it around the ILP violations and around when they're trying to discontinue the client. DSS not showing documentation of the APS or CPS referral. Again, that's going through the case comments or their evidence packet. And DSS failing to provide documentation of what they're alleging. So in this fair hearing, a recipient did not keep an appointment under her independent living plan due to her ADHD, and DSS failed to provide that proof. I've also seen some cases where DSS does not provide a full ledger of missed payments as part of their evidence packet, or showing if this is a first or second violation under the ILP. So the judge found that DSS did not meet their burden there. Okay, next slide, please. So how to lower share? There are very, very few arguments for lowering the shelter share. It's a very, very difficult thing to do, if it can even be done in some circumstances. If DSS finds that there are physical or mental impairments causing noncompliance, paying the full share, then DSS may revise the ILP. Revising the ILP can include adjusting the shelter share. Can argue that if a client has, you can argue that if a client has income earmarked for certain things, DSS cannot count it as available income to calculate shelter share. So an example, cash that is earmarked for essential items such as transportation expenses, for employment or medical needs, food or necessary items of need. This kind of goes back to the transportation issues for the walking impairment examples, something like that. Next slide, please. So other situations in which DSS may discontinue THA. These are basically ILP violations, if they're in there. So failure to submit housing search, failure to seek permanent housing, failure to submit a job search, take part in employment and training programs, failure to participate in rehab services, failure to participate in child support enforcement program, failure to apply for SSI benefits, failure to meet requirements for location of resources, failure to accept permanent housing, and other failures to comply with the ILPs. So unauthorized overnight guests, creating an unsafe environment, drug use, anything written in the ILP. So for challenging DSS's decisions on these issues, look to the evidence packet and see if DSS met their burden. So regarding job searches due or employment classes missed, check the evidence packet and the case comments to see if the client was notified about these classes. And for these situations, you can also argue that impairments prevent people from being able to comply with the ILP, these ILP requirements. For example, there's another fair hearing, and that's 8169024, N as in Nancy, where the appellant was not able to complete a housing search because he had COPD. He became too winded when he was walking as little as 2 blocks, and due to some hearing issues, had problems even hearing landlords over the phone. So the judge actually found in favor of that appellant because COPD and the hearing issues were the cause of his noncompliance, not being able to participate in the housing search. Next slide, please. That was it.
Awesome. Thank you so much, Brindle and John. We do have a few questions in the chat. So let me just go grab them. If anyone else has any questions, feel free to put them in the chat. Also, if you have questions that pop up after this presentation, feel free to email me and I will pass them along to John and Brindle. Okay, so let's take a look here. So one of the advocates asked if the client is homeless, how are they contacted?
So the notices will typically go either to the hotel or the shelter. Sometimes the notices are addressed to DSS if the client isn't at a consistent hotel placement, that they'll be placed there, or it'll be an address that the client has given them where mail can be sent to, maybe a PO box or a family member's address. But those are usually the way that they try to send the notices out. And there are if the client claims that they're um sometimes when DSS doesn't know where a homeless client is, they'll terminate the THA based on whereabouts unknown. There's pretty strict requirements on what they're supposed to do. They're supposed to send notices out to the client before they do that. If you face a situation where DSS claim that they don't know where the client is, if you check the regs and directives on that, it's a pretty strict requirement on what they're supposed to do before they do it, and we've been pretty successful when that's happened and they didn't do what they were supposed to do.
Thank you. We just have a few comments in here about different things. Someone did ask who can help with changing the law for shelter share. Now, unfortunately, we cannot advocate for the change in the law as an organization, so I don't think we can comment on that. But that's certainly something that you can speak to others about. How can clients exit the shelter with these high payments? So that's probably definitely an issue I'm sure everyone has experienced. But I don't know if you want to make a comment on that.
Well, I will say that there is something new. I assume it's both in Nassau and Suffolk, that there's a RSP program, rent. Blanking on the acronym, what it stands for, but there is, at least in Nassau County, there is a program where if a client's eligible, usually someone that's homeless, is screened by, I think Nassau County contracts it out to another organization who will determine if someone is eligible. It basically acts like a Section 8 voucher where they get a voucher to find housing, and they pay 30% of their income towards it. Um, they're still part of, I guess, it's still part of like um, I guess it's something that they could talk to their caseworker about to see if they would be eligible for that program. I know at least in Nassau County, DSS contracts it out to another organization to determine eligibility for it. I think Suffolk may do it internally, but I'm not 100% sure on that. But they can ask about the RSP program. There's also if a client finds and maybe this is something that a social worker or caseworker at DSS can also assist them with, is um, if they're able to find a room, they can get a shelter supplement payment. So sometimes like a room could be $600 or $700. DSS could be paying the full amount of that through the rental the shelter supplement program. So those are two things for clients that are homeless. It's not, they're not great options because it's very limited. The eligibility is pretty strong, but it is, again, it's not a surprise when someone's paying more than 50% of their income towards the shelter share that they're also going to have a hard time not just paying for any other necessities, but finding new housing is going to be a challenge.
Mhm. Yeah. Yeah, Suffolk does have a program, and the last I heard that it was going through the homeless shelter. So the social worker at the homeless shelter would be assisting with those applications. But I can get that information and send it out to everyone as well on the RSP programs when we do the follow-up afterwards. Okay, let's see here. Aside from income, what's the reason a client can be denied to be represented in a fair hearing?
I guess it's like our eligibility criteria. I mean, typically, with our agency, with at least public benefits, it's income. Uh, if they're more than their income is more than 200% of the federal poverty level, they're over our income guideline for the unit. And there's also an asset guideline, but typically that's not usually an issue for this type of population. Other units have different criteria. So our Veterans Rights Project, who also can represent client or veterans uh, facing homelessness in this type of situation, don't have a typically hard income guideline. Our Mental Health Law Project, the same. So I think it's best to just have your client call, get screened to see which unit potentially could help them, because not all of our units have the same income guidelines. And another hard limitation because of LSC is we are not able to represent clients that are undocumented.
Yeah, and if you ever have a question that you have before you make a referral to our organization, if you have a question about the client, like what their circumstances are, you can always give myself and Kathy Lucidi a call with the Legal Support Center for Advocates so that we can ask those questions before you send the referral. And we'll put our information in the chat in a minute. Okay, let's see here. So someone wrote, I guess, is there anything we can do for clients besides request a fair hearing for every decision not aligned with DSS's guidelines? I don't know if there's an answer to that, but
What was that question, Sharon? I'm sorry.
it was, what can we do for clients besides request a fair hearing for every decision not aligned with DSS's guidelines?
John, do you want me to answer that one?
I was
Sorry,
going to take a
yeah,
stab at
yeah,
it
that's
too.
fine. Yeah.
Like,
So another option is to have a conference with DSS. From what we understand, that's the caseworkers try to just work it out with the client. I think the fair hearings are better. And then if it's something like a notice being improper, I guess you could tell DSS that it's improper, but then they'll just fix that, and that's kind of a fast track to getting the client out of the THA. So that could work against you. I think the fair hearings are better.
and documentation, like help gather the documentation as advocates. It's all about gathering all the facts and the documentation, support and documentation to whatever they're fighting. So keep that in mind. And a lot of times I know our clients will come in and they'll have like a bag full of things, like, organize all those things that are in the bag that they're going to be coming into the office meeting with us with. That's a big problem from time to time. Just, sometimes when they're overwhelmed, they don't even open their mail. So that's something as advocates that you can all do, is help them get organized and make sure they keep every little bit of paperwork that they have, every interaction back and forth with DSS.
Kathy, do you want to introduce yourself?
Hi, I'm Kathy Lucidi. Sorry, I've been getting pulled away while I'm in this up. I'm the Director of Community Relations, and I work in the Legal Support Center for Advocates. I'm also a paralegal. So my extension here is 3324 for advocates only. I don't deal directly with the clients. Please call me if you have any issues with your clients that you need to discuss. If you want to refer a client over to us, you can call me as well. And once again, that extension is 3324.
Yes, and I also put it in the chat. Okay, so this is another question. I've had many clients refuse THA because of the shelter environments / conditions. i.e. theft, physical abuse by other residents, etc. How or who keeps up with inspecting shelters?
Kind of outside of scope. I don't have I mean, DSS, if they have a contract with the shelter, they should be also inspecting them. Uh, I'd imagine that OTDA also regulates the shelters, but I don't have a definitive answer on that. I'm not 100% sure who's in charge of inspecting the shelters. I don't know, Brendel, if you happen to know that answer.
I know that DSS says they visit the shelters and the hotels that they have contracts with to make sure the rules are being followed. I do not know if I don't know who's above them, if there is anybody checking that. So I don't really know the answer.
And there are times where you could request a reasonable accommodation. In other words, for certain things in the shelter, like if it's somebody that can't climb stairs, or in something physically where they can't do something like that, you can request a reasonable accommodation as well. Like if somebody, I've gotten calls in the past where there's roaches, and if somebody has a child who's highly asthmatic, that's something that you can request not be in place there. Unfortunately, they're so inundated with people in shelters that they kind of just put them anywhere. And there are ways that you could request a reasonable accommodation, especially when it comes to health conditions. So keep that in mind.
Okay. Let's see. Someone also made a comment about having a client ask DSS about Mitchell Llama program and family eviction prevention subsidy. They told the client they don't know about those programs. Are you familiar with those programs? The Mitchell Llama program and family eviction prevention subsidy? No. Okay, so doesn't seem
I
like
feel
that's
like
a
those are,
Somebody
City?
just commented they're in New York City.
yeah,
they're
I
in
was
New
just
York
about to
City.
say, I
Okay.
feel like the FEPS is definitely New York City. Mitchell Lama is, yeah,
Okay, so that's
city
why
stuff.
DSS is unfamiliar. Okay, will the slides, and thank you, Liz, for answering that. Will the slides be available? Yes. So I sent them out earlier today. But I will also, once the recording is available, I will also be sending them out again with the recording once we have it edited. Okay. Let's see here. So someone asked, when a client goes to an assessment to a qualified professional, are they sent to places like IMA, who routinely provide negative reports against the claimant? And if so, what recourse does an advocate have to refute the report?
So I actually don't know the answer to that, whether it's an IMA doctor or if it's a private doctor. And regarding recourse to refute the report, I feel like that would be really case specific. What condition does the client have, and what did the doctor do to investigate? What are the comments in their report? So I don't have an answer to that second part. Like I don't have a solid answer to that second part, other than it would probably be case by case. But I don't know if it's an IMA doctor or a private doctor.
As far as the second part, I feel like if your client had their own doctor do an evaluation and contradicted whatever the assessment, I think that would be really important. So if you have, a doctor's letter or medical provider's letter that seems to contradict the assessment, I think that's worth, pushing and challenging it.
Thank you. Someone also did comment about New York City. Apparently, you don't have to pay in New York City, but I don't think we can comment on New York City DSS because we're not familiar with that. We don't practice in New York City. Someone also mentioned that OTDA does come to the shelter yearly for inspections. Let's see here. Any other questions? So someone, so Someone said I got a call from a 75-year-old living with no light, heat, and no water. I don't know if that's in a shelter or not, but you can definitely you have the 75. You can call us directly and we can talk about it after the presentation, so we can figure out what's going on. Okay, so any last questions before we close today? Like I said, if you have any other questions, please feel free to call us, email us. Kathy is here. I'm here. We have a paralegal also, Hannah Fitzpatrick. And any questions, that we can't handle, we'll ask John or Brendel or anyone in our Suffolk County Public Benefits Unit for the Suffolk County issue. But I will be sending out the slides and also the recording once it's ready, and also the information for the domestic violence presentation that's coming up on April 16th. Okay, so thanks everyone for coming today. There is a survey once you close, if you could answer it. Gives us ideas on other trainings as well, so we appreciate it. So thank you so much and have a great day, everybody.